28th of May, 2025. A federal commutation order lands at ADX Florence, Colorado. 6 life sentences for Larry Hoover, reduced to time served. But a 200-year Illinois state murder term remains. Miles away, Jeff Fort's First Step Act petition sits denied. A judge in October 2023 ruled his 80-year terrorism sentence still warranted. In Texas, death row inmate Richard Tabler's contraband phone calls once triggered lockdowns across more than 100 prisons. In Florida, MS-13 member Mario Rivera coordinated fentanyl shipments using prison phones in contraband cells. California's Ashker settlement in September 2015 promised to end indeterminate solitary based on gang status: 7 men, 7 concrete boxes. One question: if Supermax and solitary cannot stop orders from moving, when does a sentence truly protect victims and communities? This is a story about command measured in kites, phones, and policy memos, and what justice means when walls prove porous. Federal judgment from 1997. This document adds 6 life sentences to a man already serving 150 to 200 years, crystallizing the public expectation that multiple life sentences mean leadership is over. A clerk stamps a federal judgment in 1997, adding 6 life sentences to Larry Hoover, a man already serving 150 to 200 years for the 1973 murder of William Pookie Young in Illinois. The federal counts, continuing criminal enterprise, extortion, money laundering, stack on top of the state murder conviction like layers of concrete. Each layer promises finality. Larry Hoover founded the Gangster Disciples in Chicago. The state of Illinois convicted him of murder in Cook County in 1973. Nearly 25 years later, federal prosecutors in the Northern District of Illinois secured 6 more life terms for conspiracy charges tied to drug trafficking and violence stretching across state lines. The public hears 6 life sentences and imagines absolute incapacitation. LWOP, life without possibility of parole, means a sentence where the person will never be eligible for parole. Appeal posture describes where a case currently sits in the appeal and clemency pipeline: direct appeal, state post-conviction, federal habeas, or clemency petition. Hoover's direct appeals on the federal charges have been exhausted. His current posture centers on clemency advocacy and challenges to his Illinois state sentence. Yet trial transcripts and prison intelligence files describe something unexpected. Prosecutors alleged that Hoover directed Gangster Disciples business from inside state custody, then continued from federal Supermax cells. The allegations span decades, from state segregation units to ADX Florence, the highest security federal facility in the nation. William Young's family waited for finality. Communities harmed by gang violence waited for safety. The docket shows layers of proceedings that stretch well beyond the original sentencing date. If a man with overlapping state and federal life terms can still be treated as a security threat, what does enough time really mean for victims and communities? C-SPAN footage from 1968. A young Jeff Fort answers senators' questions about Chicago street gangs. 2 decades later, a federal terrorism judgment sends him into the deepest tiers of isolation. C-SPAN cameras catch a young Jeff Fort in a Senate hearing room in 1968, answering questions about the Black P. Stones organization in Chicago. The senators want to understand youth programs and federal grants. 20 years later, Fort stands before a different federal tribunal. This time, the charge is conspiracy to commit acts of terrorism on behalf of Libya. Fort's Black P. Stones evolved into El Ruken. In the early 1980s, he faced drug trafficking convictions. Then, in 1987, federal prosecutors in the Northern District of Illinois charged him with conspiring to conduct terrorist acts in exchange for Libyan funding, along with weapons offenses. The court imposed an 80-year terrorism sentence. A subsequent 1988 Illinois state murder conviction for ordering a 1981 killing added more time. Fort's total effective sentence runs approximately 168 years. Direct appeals failed. In October 2023, a federal judge denied Fort's motion for early release under the First Step Act, a statute designed to reduce certain outdated sentences. The court found Fort's terrorism-linked sentence still appropriate despite his age and the decades already served. Fort remains at ADX Florence under highly restrictive conditions, including long-term, no human contact orders. SHU and SAMs, security housing units and special administrative measures, are forms of extreme isolation and communication limits designed to control high-risk prisoners. Mitigation refers to evidence such as trauma history, mental illness, or positive change offered to reduce blame or sentence length. Supporters of Fort raised his age, time served, and potential for community leadership in compassionate release efforts. The court was not persuaded. The public hears terrorism sentence and imagines complete incapacitation. FBI and local law enforcement sources describe attempts to prevent Fort from issuing instructions even inside Marion and later ADX federal prisons. When a terrorism framework meets gang leadership, should mitigation like age and decades served ever outweigh fears of control from the cell? A folded scrap of paper passed under a segregation cell door contains nicknames, a date, and a dollar amount, illustrating how command moves through the tightest housing tiers. A folded scrap of paper passed under a cell door in a segregation tier contains a few nicknames, a date, and a dollar amount. This is a kite, prison slang for an unauthorized written message. Investigators pin photocopies of such scraps onto corkboards labeled gang directives. The scraps become evidence that leadership persists even in solitary confinement. Many viewers picture solitary as total silence and complete isolation. In reality, investigators describe command moving through kites, door-to-door shouting during controlled movements, visits from associates posing as family or legal representatives, and coded messages embedded in seemingly innocent correspondence. Even in high-security segregation units designed to prevent all contact, information finds channels. This pattern appears in jurisdictions across the country. In Midwestern state gang-related homicide and racketeering prosecutions, courts have grappled with how to interpret handwritten notes, drawings of crowns or other symbols, and statements from cooperating witnesses who claim to have received orders from prisoners in administrative segregation. One composite case, call him Terrell T. Baby Jackson, illustrates the archetype. Jackson's case, anonymized to protect ongoing proceedings, involves multiple murder counts, conspiracy, and gang-related racketeering charges from the early 2000s. His sentence functions as life without possibility of parole. Direct appeals have been resolved, but state post-conviction claims challenging ineffective assistance of counsel and the reliability of gang expert testimony remain in the courts. Jackson has been housed for years in long-term segregation due to his validated status as a security threat group leader. The validation process relies on coded notes, gang tattoos, informant statements, and expert testimony. Defense attorneys argue that these interpretations sometimes stretch evidence too far, attributing command based on ambiguous symbols and unreliable cooperator testimony. Prosecutors counter that without such tools, prison officials cannot maintain order or protect inmates and staff from gang violence. This preview connects to the Pelican Bay cases in California, where alleged shot callers in the security housing unit challenged the very foundation of indeterminate solitary confinement. If movement through a prison can be controlled but messages cannot, where should lawmakers draw the line between safety and overreach in segregation policy? A prison investigator's corkboard, photocopied scraps pinned in sequence, each labeled with first names, numbers, and drawings of crowns, presented as evidence of gang directives from segregation. A prison investigator pins photocopied scraps, first names, numbers, a drawing of a crown, onto a corkboard labeled gang directives. Each scrap represents a kite intercepted from or destined for a prisoner in long-term segregation. Prosecutors argue these kites prove continuing leadership. Defense attorneys argue they prove nothing more than rumor and overinterpretation. Terrell T. Baby Jackson's case is a composite drawn from multiple Midwestern state homicide and RICO-style prosecutions involving documented prison gang command chains. The underlying facts follow a common pattern. Index homicide and conspiracy offenses in the early 2000s, convictions in the late 2000s, and major resentencing hearings in the mid-2010s. Jackson faced multiple murder counts, conspiracy, and racketeering charges. His effective sentence is life without possibility of parole. Jackson's designation as a security threat group leader keeps him in high-security segregation. The classification is not based on new crimes committed in prison, but on intelligence gathered from intercepted notes, informant debriefings, and gang expert analysis. State post-conviction petitions raise ineffective assistance claims and challenge the reliability of gang expert testimony. Some federal habeas claims remain pending. At sentencing, Jackson's defense team presented expert reports on childhood exposure to violence, early incarceration, and possible post-traumatic stress disorder. The mitigation evidence painted a picture of a young man shaped by systemic failures and community trauma. The prosecution emphasized the scale of harm, multiple victims, grieving families, and neighborhoods terrorized by gang violence. The judge acknowledged both perspectives, but imposed a sentence that functionally ended any possibility of release. The ongoing post-conviction claims focus on whether gang experts overstated Jackson's power based on coded notes and informant testimony. Unlike Larry Hoover's case, where wiretaps captured voices and federal investigators documented a sprawling criminal enterprise, or Jeff Fort's case, where foreign policy evidence tied the conspiracy to Libya, Jackson's alleged command rests more on interpreted notes and cooperator statements. Defense filings argued that this interpretive framework is inherently unreliable. A crown drawing could be art, gang affiliation, or a message, or all three. A nickname on a scrap might refer to Jackson or to someone else entirely. Prosecutors countered that gang hierarchies in prison are deliberately opaque. Leaders use coded language precisely to avoid detection. Investigators must rely on trained gang experts who understand symbols, slang, and organizational structures. Without such expert testimony, the state would be powerless to disrupt command chains that continue to harm communities outside the walls. The appellate courts have largely sided with the prosecution. Judges defer to gang experts and to the trial court's assessment of witness credibility. But the questions linger. When a life without parole sentence is partly built on coded scraps read through a gang expert lens, how often should courts revisit whether those signals really proved command? And if segregation does not stop the flow of kites, what does it accomplish besides isolating a person from rehabilitation programs, mental health, services, and family contact? Jackson's case sets up a contrast with the more clear-cut examples. Hoover and Fort had wiretaps, witnesses, and international conspiracies. Jackson has scraps of paper and informants whose credibility is contested. Yet all three men share one thing: allegations that even the most restrictive housing could not sever their connection to criminal organizations. The public may assume every prison shot caller case is airtight. The record is more complicated. A hunger strike coordination signal tapped on concrete walls. An organizer in the SHU signals the start date of a strike that will draw in tens of thousands of prisoners statewide. An organizer in the security housing unit at Pelican Bay State Prison taps on the concrete wall, relaying the start date of a hunger strike. The signal moves from cell to cell. Within days, the strike spreads across California's prison system, drawing in 30,000 participants at its peak. Prisoners in solitary confinement, allegedly the most isolated people in the state, have coordinated one of the largest prison protests in American history. Pelican Bay's SHU opened in the late 1980s as California's answer to prison gang violence. The facility holds prisoners in near total isolation, 22.5 hours per day in windowless cells, minimal human contact, no phone calls, and extremely limited visits. Prisoners are placed in the SHU not for new crimes committed in prison, but for validation as gang members or associates. Validation can be based on tattoos, confidential informant debriefings, possession of gang-related documents, or association with validated gang members. For some prisoners, SHU placement became indeterminate, lasting not months or years, but decades. The only way out was to debrief, provide intelligence on gang activities and associates. Many prisoners refused, arguing that debriefing would endanger their families on the outside and brand them as informants. So they stayed in the SHU year after year in conditions that mental health experts described as psychologically devastating. Todd Ashker and other SHU prisoners filed a class action lawsuit challenging the conditions and the validation process. Ashker vs. Governor of California alleged violations of the 8th Amendment's prohibition on cruel and unusual punishment and the 14th Amendment's due process protections. The plaintiffs argued that indeterminate solitary confinement based solely on gang status without new disciplinary violations amounted to torture. The litigation stretched for years. Meanwhile, prisoners organized hunger strikes in 2011 and 2013. The strikes drew national media attention and put pressure on the state to negotiate. In September 2015, the parties reached a settlement. California agreed to end indeterminate SHU placements based solely on gang validation. Instead, the state would move to a system where SHU placement depended on specific acts or behavior, not status. Prisoners who had been in the SHU for over 10 years, based only on gang validation, would be moved to less restrictive housing if they had maintained clear disciplinary records. The settlement also created a step-down program designed to transition validated gang members back to general population. The program required participation in education, therapy, and pro-social activities. Successful completion could lead to transfer out of the SHU. The settlement was hailed as a major victory for prisoners' rights advocates. The SHU population dropped sharply. Men who had spent 20 or 30 years in isolation returned to general population or transferred to step-down programs. Families who had visited their loved ones through reinforced glass for decades could finally embrace them in contact visits. But the story did not end there. Implementation proved contentious. Some corrections officials argued that the settlement tied their hands in managing dangerous gang leaders. Monitoring orders extended for years as the parties disputed compliance. In 2023, the Ninth Circuit issued a ruling that limited further extensions of the settlement's monitoring provisions, effectively returning more control to state prison officials. Solitary confinement has not disappeared in California. The state still uses restrictive housing for disciplinary violations and for prisoners deemed immediate threats to safety. But the framework has shifted. Indeterminate solitary based solely on suspected gang affiliation is no longer permitted under the settlement terms. The Pelican Bay litigation asks a question different from Hoover's or Fort's cases. Those cases center on how far sentences can go. Pelican Bay asks how far conditions can go before they violate the Constitution. And it raises a troubling paradox. If people held decades in near-total isolation can still coordinate a 30,000-person hunger strike, is solitary controlling gang power or simply burying it where oversight is weakest? A cell phone the size of a deck of cards recovered from a death row cell. This device triggered a system-wide lockdown across 111 Texas prisons. A cell phone the size of a deck of cards sits on an evidence table. It was recovered from a death row cell at the Polunsky unit in Texas. The phone belongs to Richard Lee Tabler, a man sentenced to death for the 2004 murders of Mohammed Amin Ramouni and Haitham Zayed. Investigators discovered that Tabler used the phone to threaten a state senator. The threat triggered a lockdown across all 111 Texas Department of Criminal Justice facilities, while officials swept for additional contraband devices. Richard Lee Tabler was convicted of capital murder and sentenced to death in 2007. His case proceeded through direct appeals and state and federal habeas petitions. Along the way, Tabler's attorneys raised claims about mental competence, ineffective assistance of counsel, and mitigating evidence of long-term mental health struggles, including documented suicide attempts and evidence of remorse. The courts rejected these claims. Texas clemency authorities denied his final petition. In custody, Tabler acquired a contraband cell phone. Using that phone, he made calls and sent messages that prison investigators describe as threatening. One threat targeted a Texas state senator. When the threat was discovered, TDCJ officials initiated an unprecedented system-wide lockdown to search for phones, chargers, and other prohibited items. The lockdown disrupted legal visits, medical appointments, and family contact for tens of thousands of prisoners across the state. It also revealed the scale of the contraband phone problem. Hundreds of devices were recovered. Tabler faced additional criminal charges for possession of a prohibited item in a correctional facility and for making threats. He received additional prison time to run consecutively to his death sentence, a largely symbolic gesture, given that he was already facing execution. On February 13, 2025, Texas carried out Tabler's death sentence by lethal injection. Mohammed Amin Ramouni and Haitham Zayed were killed in a brutal home invasion. Their families waited more than 20 years for the sentence to be carried out. Tabler's execution brought a measure of closure, but the contraband phone issue highlighted a disturbing gap in prison security. Across the country in Florida, another contraband phone case unfolded with even wider implications. Mario Clifford Rivera, known as Chucky, was an MS-13 member serving a state prison sentence. From his cell, Rivera used contraband phones and corrupted communication systems to coordinate a multi-state fentanyl distribution ring. Rivera's network used the United States Postal Service to ship fentanyl from suppliers to street-level dealers. The operation moved significant quantities of the drug, contributing to overdose deaths and addiction crises in multiple communities. Federal prosecutors in the Southern District of Florida charged Rivera with drug trafficking conspiracy. In 2025, a federal judge sentenced Rivera to 210 months, 17 and a half years, in prison to run consecutively to his state sentence. The case was built largely on intercepted phone records, cooperating witness testimony, and postal tracking data. Prosecutors argued that Rivera's case exemplified how prison cells can function as command centers for transnational drug trafficking organizations. The juxtaposition is stark. Richard Tabler used a phone on death row to threaten a politician, triggering a statewide lockdown. Mario Rivera used phones in a Florida prison to run a fentanyl pipeline, fueling an epidemic that has killed tens of thousands of Americans. Both cases raise the same question. If a phone the size of a deck of cards can turn a death row cell or a prison dormitory into a command center, how far should states go, technically and legally, to intercept those signals without crushing basic communication rights for prisoners and their families? Prison officials have responded with body scanners, signal jammers, and stricter mail inspection. Some facilities now photocopy all incoming mail rather than delivering original documents to prevent drug-soaked paper from entering the system. Legal advocates argue that these measures disproportionately harm prisoners' ability to maintain family ties and access legal resources. Corrections administrators argue that without such measures, they cannot protect staff, inmates, or the public from ongoing criminal enterprises. A kite hidden in an envelope marked "Legal Mail, Confidential," California Appellate Court rules. Such communications are not privileged and may be turned over to prosecutors. A kite slides into an envelope marked "Legal Mail, Confidential." The sender is a jail detainee. The recipient is another inmate in a different housing unit. The envelope passes through the jail's legal mail system, which ordinarily protects attorney-client communications from routine inspection. But this envelope does not contain a legal brief or a confidential letter to counsel. It contains instructions: who to contact, what to say, how much to pay. When jail staff discover the scheme, they face a dilemma. Opening legal mail without the prisoner present risks violating attorney-client privilege, a bedrock protection in the criminal justice system. But allowing legal mail envelopes to serve as untouchable conduits for gang communications undermines jail security and enables witness intimidation, drug trafficking, and violence. A case from California's 6th District Court of Appeal addressed this tension in January 2023. The prisoner argued that the kite, because it traveled in a legal mail envelope, was protected by attorney-client privilege and could not be used as evidence. The court disagreed. It held that kites hidden in legal mail are not privileged communications. The prisoner was not communicating with his attorney. He was using the legal mail label as camouflage. The kite could be given to prosecutors. The ruling attempts to balance two competing interests. On one hand, prisoners must be able to communicate freely and confidentially with their attorneys. That right is essential to mounting a defense and ensuring fair trials. On the other hand, jail officials must be able to prevent illegal activity and protect staff, inmates, and the public. But the line drawing is fraught. How do jail officials determine whether an envelope marked "legal mail" actually contains privileged communication or contraband? Some jails now open all mail, including legal mail, in the presence of the prisoner, but without reading the contents, checking only for physical contraband like drugs or weapons. Other facilities require attorneys to send documents through secure electronic portals rather than by regular mail. Still others photocopy all incoming mail, including legal documents, and deliver only the copies to prisoners. Each approach has costs. Opening mail in front of prisoners is labor-intensive and still allows drug-soaked paper to enter the facility if staff do not read the documents. Electronic portals exclude prisoners without access to tablets or computer terminals. Photocopying delays the delivery of time-sensitive legal filings and can make exhibits and photographs illegible. Defense attorneys warn that overly broad mail inspection policies chill the attorney-client relationship. Prisoners may hesitate to discuss sensitive topics if they believe their mail is being read. Attorneys may avoid sending certain documents, fearing that jail staff will misinterpret them or leak information to prosecutors. The California appellate ruling offers one answer. If the envelope is labeled "legal," but the content is a rule-breaking kite, privilege does not apply. But critics ask, how do jail officials know the content is a kite unless they read it first? And if they read it first, have they already violated the privilege, even if they later determine no privilege applied? This dilemma links to Larry Hoover's clemency file, where prosecutors allege that Hoover used legal visits and mail to relay gang orders. It also connects to the lawyer mail drug cases in the next chapter. In each instance, courts must decide how much weight to give the label legal on an envelope. If courts allow jails to open, copy, and share legal letters when they look like kites, how do we protect both security and the right to speak honestly with a lawyer? A sheet of paper soaked in synthetic cannabinoids, labeled as a legal document. Corrections officer hospitalized after exposure. Sender charged with conspiracy to distribute drugs in prisons. A corrections officer opens an envelope marked legal documents. Inside is a standard sheet of paper covered in typed text that appears to be a court filing. The officer begins to feel dizzy. Within minutes, she is on the floor, struggling to breathe. The paper has been soaked in synthetic cannabinoids, substances designed to mimic THC but often far more potent and dangerous. The officer is rushed to the hospital. She survives, but the incident exposes a disturbing trend: drug-laced paper disguised as legal mail. In Albany, New York, Maya McIntosh pleaded guilty in 2024 to conspiracy to manufacture and distribute synthetic marijuana. McIntosh's operation used legal mail envelopes to introduce drug-soaked paper into New York State prisons and federal facilities. The paper, once inside, could be torn into small pieces and smoked. A single sheet could generate dozens of doses and hundreds of dollars in prison currency. The scheme relied on the protected status of legal mail. Corrections staff, wary of violating attorney-client privilege, would deliver the envelopes without inspecting the contents closely. By the time officials realized the legal documents were actually drug delivery mechanisms, McIntosh's network had sent significant quantities of synthetic cannabinoids into multiple facilities. The drugs caused overdoses, medical emergencies, and violent incidents among prisoners. In Michigan, corrections officials intercepted a similar attempt in 2025. An attorney attempted to bring drug-laced documents into a state prison during a legal visit. The Michigan Department of Corrections issued a press release warning of the tactic and announcing enhanced screening measures, including body scanners and chemical testing of paper. Synthetic cannabinoids, often called K2 or spice, are particularly dangerous in prison settings. The substances are unpredictable. Even experienced users cannot gauge potency or predict effects. Overdoses can cause seizures, heart attacks, psychosis, and death. When an outbreak occurs in a housing unit, it can overwhelm medical staff and create chaos that endangers everyone in the facility. The legal mail drug problem forces corrections departments to make hard choices. Some facilities now photocopy all incoming mail, including attorney correspondence, and deliver only the copies. The original documents are scanned for drugs, then destroyed or returned to the sender. This approach prevents contaminated paper from entering the facility, but it raises significant concerns among defense attorneys. Photocopying can delay the delivery of time-sensitive legal documents. It can render photographs, exhibits, and handwritten notes illegible. It also creates a record. If all attorney mail is copied, who has access to those copies? Could prosecutors gain an unfair advantage by reviewing defense work product? Some attorneys have been acquitted or had charges dismissed when prosecutors could not prove the attorneys knew the documents contained drugs. The legal standard, did the attorney knowingly participate in the scheme, is difficult to meet. But the chilling effect is real. Attorneys worry that any document they send could be misinterpreted, and prisoners worry that legitimate legal mail will be delayed, lost, or destroyed. The tension mirrors the kite note dilemma in the previous chapter. When drug-laced legal documents send officers to the hospital and upend whole housing units, how far should jails go in scanning attorney mail without chilling real defense work? And if states conclude that photocopying all mail is necessary, what happens to the principle that attorney-client communication must be confidential and secure? Presidential Commutation Order dated May 28, 2025, reduces Larry Hoover's federal life sentences to time served, but his Illinois state murder sentence remains in place. May 28, 2025. President Donald Trump signs a commutation order for Larry Hoover. The order reduces Hoover's 6 federal life sentences to time served. After decades in ADX Florence, one of the most restrictive federal facilities in the nation, Hoover is transferred out of the federal system. News outlets report the commutation as a victory for criminal justice reform advocates and for Hoover's family, who have argued for years that his age, time served, and alleged renunciation of gang leadership warranted mercy. But the commutation does not open the prison gate. Larry Hoover still faces a 200-year sentence imposed by the state of Illinois for the 1973 murder of William Pookie Young. Under current Illinois law, Hoover is not eligible for parole on that sentence. The federal commutation moves him from one form of custody to another, but it does not grant freedom. William Young's family has waited more than 50 years for finality. The gangster disciples' violence harmed entire Chicago neighborhoods, families broken by murder, communities terrorized by gang warfare, children growing up in fear. For some victims' families, the commutation feels like a betrayal. For others, it raises questions about what justice requires after half a century. Is continued incarceration still protecting anyone, or has it become purely symbolic? Hoover's supporters argue that he is now in his mid-70s, has served decades in extreme isolation, suffers from health problems, and should be given a chance to demonstrate that he is no longer a threat. They point to letters of support from family members, clergy, and community leaders who believe Hoover could serve as a voice against gang violence if released. Prosecutors and victims' advocates counter that Hoover's history shows a persistent ability to maintain influence from custody, and that releasing him would send a dangerous message to other gang leaders. The case illustrates a broader tension in American sentencing: dual sovereignty. The federal government and state governments can each prosecute and punish the same person for related conduct. In Hoover's case, the federal government has reconsidered its punishment. The state of Illinois has not. Clemency at one level does not bind the other. This raises a difficult question. When one sovereign declares a sentence excessive but another keeps the door closed, whose view of justice should carry the most weight, the president's, the state's, or the victim's? And does the passage of time eventually require mercy, or does the severity of the original harm justify permanent incapacitation regardless of age, health, or claimed rehabilitation? Federal court order dated October 2023 denies Jeff Fort's motion for sentence reduction under the First Step Act, finding his terrorism sentence still warranted. October 2023. A federal judge in the Northern District of Illinois issues an order denying Jeff Fort's request for a sentence reduction under the First Step Act. The First Step Act, passed in 2018, allows certain prisoners to seek reduced sentences if they were sentenced under outdated guidelines that would yield shorter terms today. Fort argued that his age, he is now in his mid-70s, and the decades he has already served warrant reconsideration of his 168-year sentence. The court is not persuaded. The judge notes that Fort's 80-year terrorism sentence, imposed in 1987 for conspiring to conduct terrorist acts on behalf of Libya, remains appropriate. The decision emphasizes community safety and the unique nature of terrorism-linked gang activity. Fort's case involved not just local violence, but an alleged willingness to harm the United States in exchange for foreign funding. That aggravating factor, the court reasons, places Fort's case outside the scope of typical sentencing reforms. Fort remains at ADX Florence, where he has been held under special administrative measures for years. SAMs restrict his communication with the outside world to an extent far beyond typical maximum security confinement. He cannot make phone calls. His mail is heavily monitored. His visits are limited and closely supervised. The restrictions are designed to ensure that he cannot direct criminal activity from his cell. The El Rucan organization caused significant harm in Chicago. Murders, drug trafficking, extortion, and intimidation marked its reign. Fort's leadership role in that violence is well documented. Victims' families and community members have long argued that Fort should never be released. The court's order reflects that view, but Fort's case also raises questions about the boundaries of mercy. He is now elderly. He has served nearly 40 years. Supporters argue that continued incarceration at his age and health status serves no rehabilitative or deterrent purpose. They point to other cases where prisoners sentenced to extreme terms have been granted compassionate release late in life. The court draws a bright line. Terrorism-linked gang leaders like Fort are effectively locked out of reform statutes regardless of age or time served. The question lingers. If terrorism-linked gang leaders like Fort are categorically excluded from sentence reductions, should similar criteria apply to other prison-based command cases, or does that risk erasing the possibility of real change and growth over decades? Ashker Vita's Governor of California Settlement Agreement, dated September 1, 2015, ends indeterminate solitary confinement based solely on gang status, reshaping California's use of the Security Housing Unit. September 1, 2015. Attorneys for Todd Ashker and the state of California sign a settlement agreement ending one of the most significant prisoners' rights cases in decades. The settlement prohibits California from placing prisoners in the security housing unit indefinitely based solely on gang validation. Instead, SHU placement must be based on specific behavior or acts, not mere status or association. Prisoners who have been in the SHU for over 10 years, based only on gang validation, and who have maintained clear disciplinary records will be moved to less restrictive housing. The settlement is the result of years of litigation and organizing. Ashker and other plaintiffs argued that indeterminate solitary confinement violated the 8th Amendment's prohibition on cruel and unusual punishment and the 14th Amendment's due process protections. Mental health experts testified that long-term isolation causes severe psychological harm, anxiety, depression, hallucinations, cognitive decline, and increased risk of suicide. The hunger strikes of 2011 and 2013 brought national attention to the issue. Prisoners in the SHU coordinated strikes that spread across California's prison system, involving 30,000 participants at their peak. The strikes demonstrated both the desperation of prisoners subjected to indefinite isolation and their ability to organize collective action even under the most restrictive conditions. The settlement led to significant changes. The SHU population dropped sharply. Men who had spent 20 or 30 years in near-total isolation returned to general population or moved into step-down programs designed to transition validated gang members back to less restrictive housing. Families who had visited loved ones through glass for decades could finally embrace them in contact visits. But implementation proved contentious. Corrections officials argued that the settlement constrained their ability to manage dangerous gang leaders. Monitoring disputes stretched for years. In 2023, the Ninth Circuit issued a ruling limiting further extensions of the settlement's monitoring provisions, returning more discretion to state prison officials. California's reforms did not eliminate solitary confinement. The state still uses restrictive housing for disciplinary violations and immediate safety threats. But the framework has shifted. Indeterminate SHU placement based solely on suspected gang affiliation is no longer permitted. The Ashker settlement reframes the SHU as a constitutional issue, not only a management tool. Violence connected to prison gangs impacts communities outside the walls, families devastated by murders, neighborhoods destabilized by drug trafficking and intimidation. Yet families of prisoners who saw the settlement as a step toward more stable conditions argue that indefinite isolation bred more violence, not less, by removing any incentive for behavioral change and creating desperate, damaged individuals. If California decided that indeterminate solitary for suspected gang leaders went too far, what does it say that other states still rely on similar tactics to manage prison command? And if people held decades in near-total isolation can still coordinate a 30,000-person hunger strike, is solitary controlling gang power or simply burying it? Where oversight is weakest? Texas execution log dated February 13, 2025, and Florida federal sentencing docket for Mario Rivera, two different state responses to command from inside side by side. February 13, 2025. A line appears on a Texas Department of Criminal Justice execution log, Richard Lee Tabler, pronounced dead at 7:41 in the evening. The execution closes a case that spanned more than 20 years, from the 2004 murders of Muhammad Amin Ramouni and Haitham Zayed, through layers of appeals, clemency petitions, and contraband phone prosecutions. Ramouni and Zayed's families waited decades for this moment. Their statements, read in court and shared with media, emphasized the finality they had been promised at sentencing and the pain of seeing that finality delayed year after year. Tabler's contraband phone, used to threaten a state senator, triggered a lockdown across 111 Texas prisons. The sweep recovered hundreds of phones and disrupted operations system-wide. Months earlier, in Florida, a federal judge sentenced Mario "Chucky" Rivera to 17 and a half years in prison for running a fentanyl distribution ring from his state prison cell. Rivera's case involved contraband phones, corrupted prison communication systems, and a network that used the United States Postal Service to ship deadly drugs across state lines. The judge emphasized that the sentence should deter other gang leaders from using prison as a base for ongoing criminal enterprises. The two docket lines, Texas's execution log and Florida's sentencing order, represent very different state responses to the same problem: command from inside. After the story, viewers are invited to share, respectfully, whether they think current phone and mail controls strike the right balance between safety and basic human contact. Department of Corrections Policy Memo, date stamp 2025, beside the faded ink of an old kite, reminds viewers that even small scraps of paper and policy lines decide who holds power. A policy memo from the Michigan Department of Corrections sits on a desk, date stamp 2025. It outlines new procedures for screening legal mail, body scanners for visitors, chemical testing of documents, mandatory photocopying of all incoming correspondence. Beside it, a faded kite recovered from a segregation cell years earlier, nicknames, numbers, a crude drawing, serves as a reminder of why the policy exists. Across the country, corrections departments have implemented similar measures. New York prosecuted Maya McIntosh for sending synthetic cannabinoid-soaked paper disguised as legal documents. California, under the Ashker settlement, shifted away from indefinite security housing unit placements based solely on gang validation. Federal facilities continue to hold some prisoners under special administrative measures that restrict nearly all communication. The reforms show how From the Hole looks different now than it did decades ago. Larry Hoover received a federal commutation, but remains in custody on his Illinois state murder sentence. Jeff Fort's First Step Act motion was denied. Pelican Bay's SHU population dropped dramatically, but restrictive housing persists under new rules. Victims remain central. Memorials, vigils, and impact statements by families in cases where command from prison caused new harm keep the human cost in focus. William Young, Muhammad Amin Ramouni, Haitham Zayed, names that should be remembered, families that should be honored. A doc policy memo date stamped in 2025, beside the faded ink of an old kite, reminds viewers that even small scraps of paper and policy lines can decide who holds power. Viewers who want more calm, fact-based breakdowns of prison policy and sentencing are encouraged to subscribe and add thoughtful questions about justice in the comments.